Good afternoon, dear colleagues, ladies and gentlemen. I'm sorry for these technical difficulties, but it's important that we are all here. I'm very happy to welcome you today at the webinar about settlements in competition law, organized by Croatian Competition Agency and with the support of Croatian Competition Law and Policy Association. The purpose of today's webinar is to hear from our distinguished speakers about their experience in applying the settlement instrument in competition law. And this instrument provides for the possibility that the undertakings against which the competition authority is already conducting proceeding admit the responsibility for the infringement and gave up their right to submit the claim against the final decision of the competition authority at the review court. And then the other party of the settlement, competition authority, in return reduces the fine, usually by 10% or more, of the total amount of the fine that would otherwise be imposed on the party concerned without the settlement submission. The use of settlement allows for faster conclusion of proceedings and contributes to the procedural economy. Croatia introduced settlements only this year in the last amendments to the Competition Act from April 2000 this year. And our provision on settlement offers the possibility to settle for the party in a cartel case proceeding carried out by the agency. And the cartel participant in question can present a settlement submission in writing, but no later than 30 days after the receipt of the statement of objections. The party admits to the participation in infringement of Article 8 of the Competition Act, which is article that regulates prohibited agreements, or Article 101 on the Treaty of Functioning of the EU, and presents in writing its renunciation to dispute the decision of the CCA at court identifying the infringement. And then if the agency decides to accept the settlement submission, then it can reduce the fine by 10 to 20% of the total amount of the fine that would otherwise be imposed on the party concerned without the settlement submission. And the settlement is only valid for parties to the proceeding that have presented the settlement submission, and with respect to other parties that have not presented the settlement submission or have withdrawn their settlement submission, agency will continue to carry out the proceeding. And the settlement does not exclude the application of leniency program. So this is in short the provision of settlements that we now have in Croatian Competition Act, but we do not have any practice, so we need some advice from other countries and experts who have relevant experience in applying this instrument. And having said that, without further ado, I will now leave you in capable hands of our moderator today, which is Professor Jasminka Pecotić Kaufman, to start the webinar and to introduce our speakers and the topic. Thank you.
Thank you so much, Mirta. Welcome everyone again to this webinar on settlements in competition law, organized by the Croatian Competition Agency. I would like to greet you all on behalf of the Croatian Competition Association, Croatian Competition Law and Policy Association, and thank you so much for joining. Especially thank you to our speakers for being with us today and sharing your experiences on application of the settlement procedure. Mirta already said so much about the topic itself. So the idea is that firm voluntarily admits its participation in a cartel and in return gets a reduction of fine. And this is just a very simplified explanation. I'm sure our experts will go into the necessary details. But just to mention that this rule, this possibility was introduced, the cartel settlement possibility was introduced in Croatia earlier this year, as Mirta mentioned. And it's already there, it already exists in many EU countries, but not in all of them. So just as a side note, there is no obligation on the basis of European law to introduce settlements at the member state level. But obviously, all of these developments, so many jurisdictions, many EU jurisdictions, aligning their national rules and taking this settlement possibility as one of the procedural tools is it's happening as under the influence of the model developed by the European Commission. So its settlement notice adopted in 2008. And I was reading a bit about this earlier this morning. And then it's really interesting why the Commission first introduced this tool. It apparently, the leniency program was working so well that there were so many cartels being reported to the Commission, to the European Commission, then that it needed another tool to make for a more efficient, time efficient enforcement, because there was a backlog being created with so many leniency applications. That they created this settlement opportunity to increase the efficiency of its anti-cartel enforcement program, to be able, to deal with cases quickly, so faster, and to be more time efficient. So now the statistics is really interesting, that more than 50% of all cartel cases dealt by the Commission are settled using this cartel settlement tool. And just briefly, as Mirta already mentioned, there are many benefits of the cartel settlement procedure. I know many Croatian practitioners are listening to this webinar, and I think it's great that they're here. So expedited procedure, so everything moves faster until we have a decision. And then there is a fine reduction, and perhaps most importantly, there is a reduction in reputational harm to firms. When there is a very prolonged cartel case, it can cause harm in terms of reputation to firms. So this is, I think, a welcome development. But on the other hand, there seem to be many open questions. So legal certainty surrounding its application. Is it really? Is there appeal for using this in a concrete case? And then, especially, there must be appropriate procedural safeguards for the parties concerned, especially in terms of implications for private antitrust litigation. So the basic idea, as I said in the beginning, there is a confession and a pardon, but it may get complicated when you try to implement this, use it in your concrete case. So I'm really eager to hear more from our speakers today. So we have three distinguished colleagues from national competition authorities. We have Maria João Melícias, Portuguese from Portuguese Competition Authority. We have Dr. Nikolaos Zevgolis from the Greek Competition Authority. We have Erwann Kerguelen from the French Competition Authority. And last but not least, we have Frank Wijckmans, practitioner based in Brussels. So thank you very much for joining us today, and I'm looking forward to your expose. So I would just briefly want to introduce each one of the speakers before you start. So just a couple of words about Maria. Maria is a commissioner, a board member of the Portugal Competition Authority, responsible for enforcing competition policy in Portugal. She was a referendar of the Court of Justice of the European Union, and before that, a legal practitioner. Maria holds a law degree from Lisbon University School of Law, an LLM in trade regulation from New York University, and an MA in EU competition law from King's College London. So Maria, the floor is yours. Thank you.
Thank you, Jasminka, and allow me first to thank the Croatian Competition Agency and Ms. Mirta Kapural for the kind invitation to participate in this webinar. We are, of course, delighted to share the ADC's experience on settlements and contribute to the debate. And I thought of structuring this initial presentation by starting with a quick overview of the main procedural characteristics of the settlement procedure in Portugal, followed by a reminder of its underlying policy advantages, some of which have already been discussed, and some remarks on our approach as to which cases merit this fast-track procedure. And I will conclude with some insights or key lessons drawn from our experience on how to create proper incentives for companies to resort to this key procedural tool. And so though the settlement procedure was introduced in 2012 in our Competition Act, it was tested in practice sometime before, actually. In 2007, the ADC decided a landmark cartel case concerning bid rigging in hospital tenders, where it awarded, with a fine reduction of 50%, the cooperation of one of the participants who then opted not to appeal, and despite the lack of a specific legal provision in the Competition Act on the matter. Thus far, we have settled with 20 firms within 12 different investigations, accounting for approximately 70% of our cases. Pursuant to the law, and unlike what I hear is the case in Croatia, settlements are not limited to cartels. So they may potentially cover any type of investigation leading to the imposition of a penalty. So both in the antitrust and merger control forefronts, for example, in the case of gun jumping. Settlements essentially consist of a fast-track procedure for clear-cut infringements. They require an undertaking's acknowledgement of its participation in a competition infringement and its responsibility. This means that once the parties settle, they waive their right of appeal as to the facts that they have admitted to, and in return they are rewarded with a fine reduction. Either the ADC or the undertakings concerned may initiate settlement talks, but we hold the power to unilaterally decide at any time to put an end to settlement discussions with respect to one or more of the parties, if we consider that the discussions are not leading to any or relevant procedural gains. And this decision may not be challenged. Settlements can occur at different stages of an investigation, either before the issuing of a statement of objections or afterwards. In the latter case, a settlement proposal must be filled within the deadline for the reply to an SO. In case settlement talks are initiated before the statement of objections, we shall issue a very preliminary SO, which will contain the main facts and evidence and the range of potential fines. And from this point onwards, the parties may either agree to settle by filing a written settlement submission or disagree. In the first scenario, we will notify the companies with a draft settlement decision, which must then be confirmed in writing together with the payment of the fine. Should the parties disagree with the preliminary SO, fail to accept the draft settlement decision or pay the fine, the case will proceed under the normal track. And this is important, the previous settlement submission is then considered ineffective and may not be used as evidence against any of the parties of the settlement proceedings, of course, not to discourage resorting to this procedural tool. As regards the award for settling, there is no pre-established level of fine reduction, neither in the legislation nor in our fining guidelines, unlike the settlement notice of the Commission. So we have been following a case-by-case approach. The obvious concern here is to strike a right balance between settlements and leniency, because they're complementary tools and can be used actually in tandem in the same case. Whilst leniency is meant to detect cartels and collect relevant evidence, settlements are meant to achieve procedural savings and internal efficiencies. In a case a firm applies for both, the reduction granted for leniency will be added to the one applied under the settlement procedure. And we have tried to ensure that the fine reduction granted under settlements doesn't have a chilling effect on leniency applications. And in practice, in most cases, the fine has been, the reduction has been of 10%. The advantages of settlements are quite straightforward, but I think are still important to recall here. From an enforcement or public policy standpoint, they reduced administrative and litigation costs, given that the length of investigations is significantly shortened. To give you an idea, Under the standard procedure, our investigations have lasted between 9 months and 5.5 years, the longest cartel investigation so far, whereas our quickest settlement case just took us 5 months to close. We settled 5 cases in the last couple of years, all of which took between 5 and 10 months to close. So we managed to streamline the procedure. And of course, these procedural savings allow us to reallocate the resources thus spared in new additional investigations, therefore improving the effectiveness of our enforcement record. From the fund's perspective, there are important benefits as well. First, the fine reduction, and second, savings in time and resources that would otherwise be allocated to litigation, to the defense of the case. And third, perhaps more importantly, mitigating reputational effects. A lengthy antitrust investigation is likely to bring the names of the companies involved in the media much more times than a fast-track settlement procedure. And we have come to find that the main incentives for companies to resort to settlements, possibly even more than the fine reduction, is being able to control better these collateral effects. And I think it's noteworthy in this respect that we may also impose fines on individuals. So board members, directors, managers may be deemed personally liable, not only when they personally commit an infringement, but also if they knew or ought to know of the existence of an infringement in their organization and did not take any measures to terminate it immediately. And we've been applying this tool. We sanctioned a total of 36 individuals in recent times. And our experience has taught us that once we send charge sheets to individuals, companies tend to volunteer much more quickly to settlement talks in order to mitigate fines and reputational effects. Finally, companies also try to a certain extent to limit exposure to damage claims, because a final decision in a settlement case is likely to be much more concise, much less detailed than a decision carried out under the regular track. In order to ensure that this tool is successful, I think it's important also to bear in mind which cases are eligible for settlements. Of course, clear-cut infringements that merit a penalty. This is not explicit in the law, but the fact is that we will not pursue settlement talks unless we are completely persuaded of the merits of the case, that we have found an infringement to the required standard, that is, that we hold sufficient evidence to proceed with the case under the normal track at any time if parties fail to cooperate. So, in other words, we do not initiate settlement talks with a weak hand, so to say, and I suppose that companies would know that if we did. Of course, if we feel the need to test some novel theory of harm, for example, because certain behavior is causing a negative impact on consumer welfare, that is the type of case that probably should go to court or be solved through a commitments decision without a penalty, with no fines. So our experience has shown that it's important to have a flexible but also firm approach when it comes to settlements. So we do not welcome settlement talks targeted at bargaining with the ADC the merits of a case, the scope of the objections raised, or the sufficiency of the evidence. Of course, parties are perfectly allowed to do that, but they should follow the standard track in that case. So the point is that the settlement procedure is not a plea bargaining exercise, and we do not welcome prolonged discussions which would disrupt the procedural efficiencies which are the point of having settlements. Finally, settlements are much more likely to be successful in cases with a fewer number of undertakings involved. And thus far, we have initiated or accepted settlements in cases with a maximum of 5 firms. This would take me to the question of hybrid settlements, but I'm mindful of my time, so if I have time in the second round, I will go back to the pros and cons of hybrid settlements. I will just conclude with some of the main insights or key lessons drawn from our experience as to how to create incentives for companies to resort to this tool. First, I find it important to have guidelines on setting fines and be consistent in one's decisional practice with regard to fines. And regardless of the specific methodology one may use in this regard, I think it's fairly consensual to say that it's good to have a method, because in order to be encouraged to settle, companies need to know what they're up against. I mean, they're getting a fine reduction, sure, but a reduction from what? And guidelines are also helpful in setting the main parameters around which the discussions are supposed to evolve by making it easier for the addressees to understand the level of the fine to be applied. Guidelines reduce the perception of unfair special treatment, which is all the more relevant in cartel cases. So being consistent in one's fine policy facilitates the settlement process and encourages this process. Second, we find, as I've said, the possibility to impose administrative sanctions on individuals or a ban from participating in public tenders in the case of bid-ringing investigations. This renders our competition law toolbox more complete, in that it provides additional deterrence, while also creating incentives for companies to settle. A ban from public tenders is yet another tool we have in our arsenal, which we have used in practice and will continue to do so whenever appropriate. And we do have discretion to impose these sanctions or not, and we may decide, of course, not to do so in the context of settlement discussions. Third, it is pointless to have vigorous enforcement if companies do not actually feel the pain by paying the fines. In other words, it is crucial to have your cases upheld in courts to ensure the credibility and effectiveness of competition policy as a whole. So a sound judicial track record enhances the incentives for companies to settle. And let me add that at the ADC, we do not compromise when it comes to due process. I usually say that for us, it is like breathing. It's naturally embedded in our DNA. And I believe that our success rate in court is a strong testament to that. For example, in 2020, our overall judicial success rate was of 92%, meaning that of a total of 85 judicial rulings rendered last year, 78 upheld our decisions, 6 were partially favorable to the ADC, and only 1 decision got annulled on procedural grounds. Furthermore, our decisions were fully upheld on the merits, so 100% success rate there. Fourth, and finally, in order to ensure the success of this tool, it is important to have a proper interplay between public and private enforcement. As you said, as private enforcement gains traction in Europe, it becomes very important to create the right incentives not to undermine the attractiveness of the settlement procedure or leniency for fear of exposure to damages. And Portugal is no exception here, because we do have a very favorable private enforcement regime, including opt-out class actions and a specialized competition court. Some examples of adjustments we have made in law and practice in order to achieve this goal include the absolute protection of settlement submissions. So further to the implementation of the damages directive, we have made specifically clear in the law that submissions filed during settlement talks that for some reason fail and thus become ineffective, though remaining in the file, are absolutely protected from disclosure to third parties, including to those seeking redress. And in hybrid cases, in order to protect settling firms from being overexposed to damages or more exposed than non-settling firms, we are only releasing non-confidential versions of settlement decisions once the investigation is concluded. So once the standard track procedure is also concluded. Finally, and according to the draft reform implementing the ECN Plus directive, which is currently still under discussion in our parliament, settlements will be rendered more flexible by including the possibility to settle even after the reply to the statement of objections, by allowing firms merely to accept not to challenge the facts and their participation in an infringement, and not necessarily to positively acknowledge or confess those same facts. This was a request brought to us by stakeholders in the context of the preparatory works of the draft legislation implementing the ECN Plus directive, which we coordinated so as to make these two more attractive. The consequences in any case will be the same, that the parties will not be allowed to challenge on appeal the facts and their legal qualifications. So in conclusion, the effectiveness of our enforcement record and of competition policy as a whole relies significantly to the extent to which we're able to reduce the length of our investigations, increase procedural flexibility and efficiency while not compromising on due process, and settlements are a crucial tool to achieve these goals. I will stop here. Thank you for your attention. So back to you, Jasminka.
Thank you so much, Maria, for your very interesting and extensive, detailed presentation. It's not really hard to see why Portuguese competition system is considered as a role model for many perhaps smaller and medium countries, also in Eastern and Central Europe. So
I hope so. Thank you.
I'm very happy that you outlined that there is a variety of enforcement tools you use and guidelines, which are very, very important for making sure that tools like settlement, cartel settlement procedure really work in practice. We will come back to questions later in the Q&A. So thank you so much, Maria. We'll go ahead with Dr. Nikolaos Zevgolis. He's ex-commissioner rapporteur of the Hellenic Competition Commission. He's a lawyer and legal expert in the Directorate General for Competition of the Greek Authority. He has been teaching at the Open University of Cyprus, Hellenic Open University, and Athens University of Economics and Business. He published in a number of peer refereed journals, such as European Journal of Law and Economics or European Competition Law Review. And he co-authored the monograph on competitive effects of minority shareholdings, published by Bloomsbury or Hart publisher. So, Dr. Zevgolis, the floor is yours.
Just a few words about the Greek legal system. The law for the protection of competition came into force in 2011. However, there was a provision about the settlement procedure 5 years later in 2016, and the Hellenic Republic considered that after 3 years, in October 2019, that it was time for an amendment about the settlement procedure. The reason for this amendment was legal certainty. Some of the cases that have been already examined by the Hellenic Competition Commission in the meantime, between the years 2016 to 2019, shown that it was necessary to interpret competition law and law for public tenders in the same way, avoiding potential contradictions. At the next slide, we have some numbers. Very simple. We have this 5 years of application of the settlement procedures, 11 cases in Greece. Most of them are hybrid cases. For those who are not familiar, some of the companies involved decided not to settle. 10 of our cases concern cartel. However, there is also one case about which I'm going to say some details in two of the next slides, concerned the obstruction of an on-site inspection by the members of the Hellenic Competition Commission. So let's go to our first settlement decision, which concerned the market of high quality and price cosmetics. The interesting thing in this case is that it was about a cartel constituted by members of the same family, and the Hellenic Competition Commission in this case imposed fines in total more than 1 million euros. The companies involved unreservedly admitted their participation in the infringement with the object of restricting the competition during the period June 2003, June 2006. Actually, it is a quite old prohibition, and for their cooperation and acceptance. The HCC reduced the fines imposed for each company involved by 15%, which is the specific reduction in our law, in accordance with the provisions in force. The second case, which is maybe the most important case in our law regarding cartels, concerned bid rigging regarding tenders for contracts in public infrastructure projects, in particular road construction, modernization and upgrading of roads, constructions of new highways, transport projects, for example, metro, railways, airports, and ports. And 15 of the companies involved decided to settle. And this case is very important for us because it is the first time that the leniency program worked successfully in our country. It was about a joint plan for bid rigging of public works tenders during the period 2005 to 2012. And in this case, the Hellenic Competition Commission imposed a total fine of more than 80 million euros, which is the largest fine so far in our history. I won't say many details about each case because of the time, but the slides are, you can have access at the slides, or you can ask it for me by email. Let's go to the next case, which was a settlement case regarding the production and marketing of dairy products market. Why this case is interesting? Because actually we had a cartel between a dairy farmer and a wholesaler. Can we have a cartel between undertakings which are at different level of the markets? The Hellenic Competition Commission in this case considered as a cartel the agreement between these two undertakings for the non-simultaneous participation of both companies as competitors in public tenders. For example, for milk tenders for milk by the army, the Greek army. So their informal agreement included the prior consultation and consent of Friesland company for the participation of the other company in the major tenders, and no consent was required for the participation of the other company in smaller tenders. At the next slide, we have a settlement case regarding the duopoly in Greece in the press distribution agencies. Duopoly until 2017, because nowadays it's about a monopoly. So the two press distribution agencies which were activated in Greece were involved in anti-competitive collusions, which constituted horizontal agreements or concerted practice with a view to agreeing a common trading and pricing policy, supplies, the restriction of quantity of supplies, the distribution of customers, etc. So the total fine in this case was €500,000. At the next slide, we have a settlement case regarding electrical service sector. It is an interesting case because in this case, we have the involvement of unions of undertakings. Actually, it was about the 11 primary federations from practitioners in the electrical services and their secondary electricians federation. The interesting thing also was that in their code of ethics, there were provisions about price fixing, and the unions involved in this case decided to settle. There was a small amount for the fines in total, and they were obliged for retraction from their statutes and code of ethics of the provisions which contradict the provisions of the competition law. One more settlement case regarding the transport companies in a specific area of Greece, the area of Kavala, for those who are familiar with the Greek countryside. And in this case, we have also involvement of one union of undertakings. The next slide, we can see one more case regarding public tenders and public works contracts in a specific area of Greece. We have again a manipulation of the tender, and I would like to underline here that in a short time we can see that it is about the second settlement case that concerned the public works sector, in which interested companies expressed in practice honestly and voluntarily their interest for settlement. I spoke on the fifth slide about the second case, and we can go to the next slide, which concerned again tenders, public tenders, regarding a specific University General Hospital in Ioannina, an area of Greece. The public tender concerned the supply and equipment of this hospital. And I would like to underline here that this is the second time that the leniency program worked together with the settlement, which is very important. And we have also at the next slide, again, a cartel regarding tendering procedures, not public tendering, but tendering procedures in the market of security services. We have a total amount of fines more than 688,000 euros. And now is the case which is concern not a cartel, but it is about an active cooperation by Coca-Cola. This is the reason why we call it Coca-Cola case. And it was a kind of a settlement. In this case, there was a imposition of a fine on Coca-Cola by the Hellenic Competition Commission for obstructing an on-site inspection in the context of an investigation by the Hellenic Competition Commission in the non-alcoholic beverage market. The problem was in that case that during a dawn raid, employees of Coca-Cola moved and deleted messages from their mail accounts. And as you know, this was problematic. So the final decision was that on the one hand, to impose a fine totaling 800,000 euros on Coca-Cola, and on the other hand, not to impose a fine on the employees of Coca-Cola that have been involved in this specific case. I would like to underline here that in this case, the Hellenic Competition Commission followed the practice of the European Commission, quite similar for non-cartel cases. So it is not a clear settlement case, but it can be considered as such one. let me remind you that in a series of cases has been already been judged by the European Commission that this case did not concern cartels, and the involved companies were rewarded for their cooperation in the administrative process by reducing the final fine from 30 to 50%. Let's see the result. The total sum of settlement fines since 2016 due to the settlement procedure is approximately 85 million euros, which in my view is not bad at all. The 11 above mentioned settlement decisions have not been appealed, which is very important. And this thing means efficiency and effectiveness by the Hellenic Competition Commission. What are the main reasons for the success of the settlement system in Greece? Of course, there's attractiveness of the benefits for those undertakings that will participate successfully in the settlement procedures. First of all, we have economic benefits, 15% reduction, specific amount, of the fine imposed, which is, let me remind you, more than the 10% provided by the European Commission settlement decisions. Is this the only reason? No, it's not the only reason. There is also a very significant waiver from criminal sanctions and other important administrative consequences. For example, no exclusion from public procurement procedures or concessions in the future for the companies that are going to settle effectively. The basic rule in Greece, slide 70, the basic rule in Greece regarding all those who are involved in cartel cases is that there is going to be also a term of imprisonment for at least 2 years and a fine of between 100,000 euro and 1 million euro for these people. So the settlement procedure in our law system creates an exception, which means there is a waiver from any criminal liability, and which is going to be granted and for the crimes associated or connected with the crime of cartel. For example, fraud. Let's see, fraud regarding a public tender, a bid rigging. Furthermore, there is also an exception from administrative exclusions, which is very, very important for all those undertakings who are involved in public tenders. So, the finding of the relevant infringement due to the settlement procedure shall not establish grounds for exclusion of the undertaking from public procurement procedures or concessions, except, of course, the repetitive breach provided for in Article 1 of our system or Article 101 TFEU. There is also in the law interpretation of the sense of repetitive breach, which is that a repetitive breach shall mean the issuing of a relevant declaratory decision within 6 years from the earlier issuing of another declaratory decision. Which are the concluding remarks of our system? First of all, there are gains for the state. There is no appeal, which means easy money for the Greek state, from the significant fines having been imposed the last 5 years. Gains for the companies, obvious gains for the companies. Not only, it's not only about economic motivation, 50% reduction of the fine, but also exemption from penal and administrative exclusions, as I explained before. And also, there are gains, serious gains for our authority. There's obvious efficiency gains regarding the procedure. And there is also an improvement of the leniency program. And at this point, let me remind you that it must be understood that leniency and settlement neither compete each other nor undermine each other. And I will finish my presentation with this. In Greece, the law provision about the leniency program came into force in 2006. The law provision about the settlement procedure came into force 10 years later. However, it is remarkable that the first leniency case came in Greece took place successfully simultaneously with one of the first settlement cases in 2017. This means that leniency and settlement should go hand in glove, hand in hand, since they need each other. Thank you very much for your attention, and I remain at your disposal for possible questions.
Thank you very much, Nikolaos, for this very interesting presentation. It's always good to hear about cases from other jurisdictions, and you seem to have very plenty of cases from in the area of bid rigging, and I just remember the case with duopoly in press distribution. We had that one as well years ago in Croatia, so there are similarities. And I think very importantly, you emphasize that there must be clear incentives for companies to come forward and use this settlement procedure. So thank you so much, and we'll come back to questions in the Q&A session. Thank you so much for now. So next up, we have a colleague from the French authority, French Competition Authority, Erwann Kerguelen. Erwann is Deputy General Rapporteur of the Autorité de la Concurrence and Head of Antitrust Unit 3, whose responsibilities include cases involving the distribution sector. Erwann is a food engineer with a certificate of aptitude in business administration and a master's degree in competition and contract law. And he's been rapporteur at the Autorité de la Concurrence since 2011, appointed expert in 2017. He worked on the investigation of cases relating to joint purchasing agreements in the distribution sector and participated in the investigation of the decisions sanctioning the floor coverings cartel and the white goods cartel. So as I understand, Erwann, the General Rapporteur is dealing with investigations at the French authority, right?
Yeah, exactly.
Okay. The floor is yours, Erwann.
Thank you very much. So just one point, I speak only on my personal capacity, meaning I do not act on behalf of the French Competition Authority. So few words about the settlement procedure is also quite new for us in France. This new mechanism has been introduced in 2015 by the law, also known as the law Macron. After 2 years of practical implementation, the French Competition Authority published a procedural notice on the condition for implementing the settlement procedure. And before providing some insight about the settlement procedure in France, I thought it may be worth mentioning some key figures. First, the number of decisions between 2016 and now. We had 19 decisions involving settlement. The amount of fine is almost 1 billion euro, meaning that this procedure is not only used for small cases, and the decisions taken under settlement procedure amount for a significant part of the total number of decisions. This represents between 3 and 4 decisions per year in France, for an average of 180 million euro of fine. And this example can give a clue about the attractiveness of the French mechanism in settlement. Then I thought it would be interesting to point out the differences between the French mechanism and the European one. At EU level, the settlement procedure is limited to cartels, which is not the case in France. For example, we have a recent decision fining a supplier for IPM infringement, hence vertical restriction. Also, the starting point of the discussions is also different. I understand that in Portugal there is a will to change, so it could be very interesting to see how it could work. But for us, currently, the starting point of the discussions can begin only after the statement of objection. At the EU level, the discussion can also begin much before, and after there is only there is a specific delay, so there is 2 months to reach an agreement. If it's not possible, after we will come back to the normal procedure. So after, it would be interesting to see how the change in Portugal could work on the attractiveness of such a procedure. And the form also is different, whereas at EU level, the company opting for a settlement procedure must introduce a formal request to settle in the form of a settlement submission, meaning providing an unilateral document. In France, the company will have to sign a report, also signed by the prosecution services. So even if the objectives are similar, these differences can have a huge impact on the practical implementation of settlement proceedings. And in view of these differences, the French experience in settlement may provide some relevant feedback for the implementation of the new Croatian procedure. I wanted also to give some points, to develop some points about the interest of the settlement procedure. It has also been developed before, so I'll be very quick. But I think that's important to point that there should be an interest from both from both point of views, from the enforcer perspective, but also from the stakeholders perspective. From the enforcer perspective, the settlement procedure could lead to a significant improvement in case processing times. After a statement of objection, we normally face at least one, sometimes 2 rounds of contradictory proceedings before the final hearing. With the settlement, in most of the cases, the decision can be published 4 to 6 months after the SO, which is very much faster than through classical procedures. There is also an improvement in the allocation of resources after the decision, because the appeal against the decision would be limited to the scope of the fine the party agreed upon. So it's also very interesting for us. And from the stakeholders' perspective, the first advantage is, as it has been said before, the reduction of the fine that can be significant. But beyond that, the other advantage in France is also due to the predictability of the fine compared to the mechanism that existed before. Because before, there were another mechanism, and the companies could only know the likely reduction of fine they would benefit, but they could not have guarantee on the basis on which this reduction would be calculated. So finally, it was the final amount of fine could not be known by a company. So, and for us in France, I think that undertakings really wished the settlement procedure because they really wanted more predictability about the fine. And finally, I think also that beyond reputational criteria, using the settlement procedure can also have the advantage to ensure compliance in a quicker way. So that can also be an advantage from the company perspective. This is important to have in mind that this procedural choice can be combined with other ones, as it had been said before. So there is the first is that even if this is more an exception, it could be combined with commitments. When we analyze the decision between 2016 and now, we can see that 20% of the settlements also included commitments from undertakings, meaning that even if this possibility can exist, this is quite rare. Therefore, undertakings should not rely too much on commitments to reduce the fine beyond the reduction of the settlement. This is all the more relevant that the procedural notice on compliance programs published by the French Competition Authority has been updated in 2017, stating that such programs won't anymore lead to automatic reductions of fine. And also beyond the commitments, there is also the possibility to combine settlement procedure with leniency. And for example, the two cases you mentioned before, I worked on the floor covering cartel and the white goods cartel. In both cases, we had some leniency also. Now I developed some different theoretical advantages provided by settlement procedure. I think it's important to indicate that the settlement procedure is a voluntary one, so the company must officially ask for it. But above all, the rapporteur général, who leads the prosecution services in France, has to give a green light. Hence comes the question of what could be the practical criteria to assess whether a settlement procedure is relevant or not from the enforcer point of view. Such criteria are linked to the main objective of the settlement procedure. There must be a significant advantage for the enforcer, which leads to assess the efficiency of improvement of such a procedural choice on its action. To that end, I think there are two main criteria: the number of parties and the legal certainty regarding the infringement. About the number of parties, the criteria could seem obvious, but this is very important to keep in mind. The more undertakings would discuss during the settlement procedure, the more complex this discussion would be. This could also be very time-consuming, which could decrease the efficiency gains of this procedure. And for example, some of the undertakings could try to leverage a deal-breaker position, for example, and that can also be very complicated to deal with in such a case with a very large number of undertakings. And about the legal certainty regarding the infringement, there are two aspects on the level of proof. If the demonstration is backed with bulletproof elements, the undertakings will certainly be willing to negotiate as view of the high risk of being fined, and respectively the contrary. On the type of infringement also, it's more about determining if the case is about a very new infringement, or is it a very classical infringement backed with decision-making practice. I think that the more the infringement would be controversial, controversial on the undertaking's point of view, of course, the less important the incentive of the undertakings will be to really negotiate. So depending on this criteria, we can assess the opportunity to accept to enter a settlement procedure or not. And after, maybe if I have the time, a few words about the different steps of the settlement procedure. The first one is a state of play meeting. So just before the notifying the SO, the prosecution services will present the conclusion of the SO to the parties. This allows the undertakings to think upstream of the procedural choices. And it is particularly important, as I said before, in the French procedure, once the SO has been notified, the discussions must be concluded within 2 months. So that is very important for the undertakings to discuss with us from the beginning. On the second step after, it is a discussion with the undertakings. As I said before, this is quite different from the settlement procedure at the EU level. Indeed, the delineation of the infringements can be discussed only few parameters of the fine, such as individualization criteria, and at the extent it could not be considered by the judges that the undertakings try to contest the fact on which we based our allegations. Otherwise, it would be complicated, meaning that the path for negotiate is not wide open for the parties. On the third step, so the end of the discussion, once an agreement has been found between the prosecution services and the undertakings, the Rapporteur General formally sent a proposal of fine within the range, and the undertakings formally agree by signing with the prosecution services a report. And finally, after the case will be presented to the judges, we will decide of the level of the fine within the range agreed upon with the prosecution services, levels that will depend on the undertaking's arguments after. Thank you.
Thank you very much, Erwann, for a very interesting presentation, especially regarding the criteria as you laid out, important for the use of settlement instruments. So I think we see many differences between different member states, but I think this diversity is helpful for us in Croatia also to think more about what we want to achieve and how we want to use this instrument. So thank you very much. And last but not least, we have Frank Wijckmans. Frank is active in the fields of EU and competition law and Belgian business law. He's a founding partner of the Brussels-based law firm Contrast and the professor at the Brussels School of Competition, where he teaches the law of and economics of vertical restraints. He also recently published, or his report on vertical block exemption regulation reform was published at the DG Competition website. He holds a master's degree in law from the University of Antwerp and an LLM from the University of Virginia. And he's an author of very distinguished monographs published by the Oxford University Press on vertical agreements in EU competition law, distribution agreements in EU law and national laws, and then horizontal agreements and cartels in EU competition law. Very excited to hear from your experience, Frank. The floor is yours.
Thank you, Professor Kaufman, and thank you, President Kapural, for having a practitioner in this distinguished panel of speakers. I'll give a bit of a different perspective on the matter. I think that is the benefit of having indeed different profiles on the panel. My experience in the settlement area is a bit double. On the one hand, I have experience at the Belgian level, but in all fairness, with one exception, where we indeed had a settlement, and Ms. Melícias may find this interesting to hear, involving 17 parties. Most of the settlements were rather straightforward and simple. More interesting, and I would like to use that as my guide, is the experience which I had in the trucks cartel case, where I was representing one of the parties, and so much in the meantime has become public that this case is a fantastic example of all the complexities that the settlement process may bring about. I looked at the law, Article 52 of the Croatian Competition Act, and I think it resolves already two elements of legal uncertainty which we encountered in the trucks case. The first one, and that was really a nightmare for the parties, was we were finding ourselves in a post-SO stage, post-statement objections stage, when in fact the issue of potential settlement came up. And if you look at the EU rules, it is rather unclear to what extent a settlement process can still be applied in the post-SO sphere. We know in the meantime the case has been decided that is indeed perfectly possible, but the trucks case was the very first case where this happened. I noticed that Article 52 of the Croatian Act deals with that, and that it's clear that post-SO settlements are possible. Second uncertainty for the parties in that case was the extent to which there would be real willingness on the part of the Commission to go for a hybrid settlement case. It was obvious that one or more parties, in the meantime we know one party, notably Scania, that one party was not going to step on board, and there was clear uncertainty as to what the European Commission would do, because in terms of hybrid settlements at that time, its track record was not gigantic. In most cases, all parties had settled. Again, I see that the Croatian Act addresses that issue and makes it clear that hybrid settlements are perfectly possible under the Act. So that resolves already two elements of uncertainties with which we as parties were struggling at the time of taking the decision to go or not go forward with a settlement submission. Now, if I look at the Act from a practitioner's perspective, there are at least three elements of legal uncertainty that remain. The first one, of course, and that's an obvious one, and that applies in all systems, is you have no guarantee as to whether the authority will want to accept your settlement submission, and that is in the privilege of the authority. Now, and I think the public enforcers will forgive me for saying that, I would recommend to authorities to be very careful in that area. You know, I know that you know, and most of you have indeed experience in private practice, that before companies step forward and offer a settlement submission, a lot of debate takes place. This has to do with balancing risks and what have you, and certain people will have to stick out their neck before indeed they make the step forward. At that point in time, it is very important, even if a settlement proposal would be rejected, that indeed the defendants are able to understand why that is happening. This cannot be purely arbitrary. Otherwise, you kill the credibility of your settlement process. This will spread amongst the competition law community in the jurisdiction concerned. A second thing which is important is, and that's a very important one, what will happen in case of rejection with the evidence contained in the settlement submission? I know the theoretical answer. The settlement submission will be protected. But of course, let's be honest, that is not the issue. You have stepped forward. You have indeed confessed, in a sense, certain acts. You will, of course, to make your settlement submission credible, surround that with concrete indications of indeed what you are admitting. And the real question is, what will happen with that knowledge? And that's, again, a big question mark for the parties. And if I look at the Act, Article 52, paragraph 7, it states, and maybe the translation is not perfect, but that's the one I received. It says, the statement of the party concerning the submission cannot be taken by the agency as the only evidence for the identification of the infringement. You should be aware that that language frightens me as a practitioner, because in fact it means I put a settlement submission forward, it's being rejected, and the next day I can get an RFI, request for information, basically getting from me exactly the information I was confessing to and confirming in my settlement submission. So that is a key point. What happens with the evidence? A third element on which I can be very short, because I think it has been very well addressed by the previous speakers, is how sure am I that I'm getting fair treatment in terms of the setting of the fine? And we all know in practice where the problem lies. And the problem is also present in the Croatian Act, notably in Article 64, paragraph 3 of the Act. There is discretion for the authority to go up to 30% of the turnover, so you are never sure that what you're getting is also what will be imposed ultimately if you would not step forward in a settlement process. To what extent is the figure, the calculation, the one you would end up in a contentious context? I do not know how you can resolve this, but you should know that this is an element of uncertainty that always pops up in the internal discussions when parties decide to step forward or not to step forward. And then, as a sort of a last and maybe a bit broader part, Mr. Kaufman, if I may, what is the kind of strategic assessment which parties make? And again, I take you a little bit in my kitchen as a practitioner. What is the sort of balancing act which is being performed? The starting point is the admission of guilt. In other words, I waive, as a company, my substantive defense on the case. I heard the previous speakers mention a number of times that a settlement process is beneficial in terms of potential reputational damage. I dare to put a question mark next to these statements, because if you as a company settle, you admit yourself that indeed you have been committing certain infringement of competition law. Reputationally speaking, I've seen it at work in various cases. Reputationally, this may be indeed as bad as settling the case. That is something which I think you should be aware of. Reputational consequences of personal admission of guilt indeed will also in the press be played out. The return which you're getting is tangible. I do not deny that, and I'm happy to see that in the Act you are going to 10 and 20%, which is more than what you get at the European level. But the balancing, the strategic balancing which you're doing is a bit more complex than that. I admit, and I get a reduction of the fine. The world is substantially more complex. The first thing I would need to understand is what will be the outcome for me in all respects, financially, reputationally, if I do not settle. And that for me will involve an assessment as to whether there are leniency applicants involved. And of course, that is confidential. I will not know, but I will try, based on what I get in terms of RFIs from the authority, to understand what the position is. And there, of course, certainly if I'm late, I have the perception of being late with my leniency application. And again, as a party, let's not kid ourselves. You feel in the air, based on the level of knowledge of the authority, you feel whether there's a risk that you are rather late with your leniency application if you were to step forward. You have to think about the possibilities of improving your position by conducting a defense in a contentious context. And there, and I'm using that example, there, of course, the 10 or 20% must be put in perspective. Right? Just imagine that in the context of a settlement, I have to accept a multiplier of 7 years of an infringement, and that in a contentious context, I'm more or less sure, maybe on appeal, I could get it down to 5 years. My 10 or 20% has evaporated. I'm better off by fighting the case. And again, you should know that these are the kind of assessments which the parties are making before going for settlement. Now, all of that was interesting pre-Private Damages Directive and implementation, but the Private Damages Directive indeed has changed completely, has completely changed the game. At the European level, there was a speech as recent as the 21st of October by Mrs. Vestager in Rome, where she clearly said that indeed the number of leniency applications at the European level has gone down. And she doesn't need me to explain to her why that is the case, but I can tell why that is the case, because practitioners are reconsidering strategies in light of the impact of the implementation of the Private Damages Directive. The impact is huge. Look at the drugs cartel. I don't know to what extent the participants are aware. It's again public, but I think in the meantime, there are private damages cases pending in no less than 20 jurisdictions. The amounts at stake are gigantic. And the comparison, the financial comparison, is not a fine with a reduction of 10 or 20%. The real comparison here is what will the overall financial picture be at the end of the case. And there the private damages element is taking overriding importance. And there I come to the question, how does settlement fit in with the private damages perspective? Now, in my initial thinking, I thought, well, and I heard very clearly what was said by some of the previous speakers, this is not a negotiation. And I accept that as a practitioner, let's be clear. Otherwise, as an authority, I think you're wasting your time. But you need to find each other somewhere middle ground to make sure the settlement works from the broader perspective. And I think you cannot forfeit, you cannot put aside the private damages element in that context. And how can that be addressed in settlement? Well, one way of doing that is by making sure that in the dialogue between the parties, you can have an impact on the content of the decision. What we have seen is that civil judges are very much inclined to take the sort of operative part of the decision, and they're fully entitled to do that as a given, and simply apply it to the facts of the concrete cases they get in front of them. I think in private damages cases, settling parties could be benefiting from the fact that there, in fact, there's a bit more detail on the conduct rather than less detail on the conduct in some of the decisions, depending on the case. Let me give you an example. And again, what I'm telling you is not confidential anymore. Scania is defending its case before the Court of Justice in Luxembourg. And of course, one of the arguments which Scania is making is a split of the conduct, which in one part was European and the other part was local, German, one country. Now, the impact on the fine calculation of that argument, if it succeeds, is gigantic. Now, these elements also play a role in the context of private damages cases. If I have a private damages case which relates to a transaction that took place in the more recent period, where indeed the activities, the acts were being conducted essentially in one or a limited number of member states, and that is brought out in the decision, that can help me in my private damages case when I need to defend a case against a claimant that is coming from a different member state. These nuances will in the future start to matter, because in the financial balance, the fine is one element, but the private damages cases are really, probably in many cases, a more heavy other element. You should also be aware that hybrid settlements may undo a lot of what you try to achieve with having a concise decision. Take, again, the trucks case. It's public. I can speak openly about it. You have a settlement decision on the one hand, and you have the Scania decision on the other hand. It's about the same cartel, single and continuous infringement. You have a very detailed decision on account of the fact not that party settled, but on account of the fact that one party or more parties opted not to participate, went for the contentious procedure, and therefore the authority, and I fully accept that, was obliged to come out with a fuller decision, because of course it had to anticipate a potential appeal in Luxembourg. But then you're undoing one of the main benefits of your settlement process, a concise decision that helps you in your private damages cases. I will conclude with a couple of observations. Why is settlement attractive from the public enforcement perspective? I don't think I need to dwell on that. I think all the arguments have been brought forward by the distinguished speakers before me. Why is it attractive from a private enforcement perspective? You should not underestimate that the admission of the facts and the acknowledgement of the infringement is something very powerful for a claimant. So you are, through the settlement, you are in a sense indirectly stimulating private enforcement. Final point, from the defendant's perspective, I think in all realism, when I'm advising clients, the 10% reduction or the 20% reduction is probably one of the least compelling arguments on the table. There needs to be something more. And I heard, for instance, one of the previous speakers refer to the fact that you could be excluded from public procurement, that there are potential criminal sanctions, and that these additional aspects would not play in case of settlement. Well, there, as a practitioner, and forgive me the expression, I really would start to listen. This is tangible, but it is not a balancing act between admission and 10 or 20% reduction. That is not the way decisions are being made. It's a much more complex area where more needs to be on the table to convince parties to step forward. Again, Professor Kaufman, from a practitioner perspective, these were the sort of initial elements I wanted to bring to the table to stimulate the debate.
Thank you very much, Frank. Very, very interesting points. I think the question is, in my mind, is now, do we have the right incentives? Thank you so much. I think the debate is just being opened for us in Croatia. Maybe we will continue with another webinar in Croatian where we can more freely express our views. And then I think your points about strategic assessment and being clear about what goes on on the side of the firms before they decide what procedural tool to use, is very important. And lastly, I think this interplay between private enforcement and the use of settlements is very, very important. So I think you opened up so many important questions. I think in 5 minutes left, we really, I think we don't have much time, but we have a question from Judith Firnich. Judith, would you mind asking your question live? So you wrote the question, but would you mind asking
Yes, of course. Yes, of course. I just wanted to submit my question so that you can insert it to your thoughts in due time. And it's also from the practitioner point of view, my question. And from the Hungarian point of view, the first case in which settlement was applied by the Hungarian Competition Authority was a very complex case in the lead acid batteries market. So there were heavy debates on the merit of the case. Also, so I can say that it was a lengthy procedure, even if the tool of settlement was applied. And there was a consequence that the Hungarian Competition Authority also acknowledged in its decision that it had significantly exceeded the relevant statutory administrative deadline with 5 months. So there was an additional procedural issue in this case, which we also had to consider when we assessed from practitioner point of view the complex issue of how to advise our client. As you could see, our client was heavily relying on public procurement. So there were three parties, and two parties were decided to go to the Curia if it's necessary, to the Supreme Court in Hungary, to use any potential legal tools to find a solution. So the decision was made to go to the Metropolitan Court and then to the Curia, and it's very important to call at this point to call the attention to the time and procedural dimension as well, because the Hungarian Curia accepted, after all, this argumentation by the parties, and it emphasized that the establishment of time limits for substantive administrative sanctions is intended to prevent the clients of the administrative procedure facing an administrative sanction, but being adversely affected by the fear of being threatened for an indefinite period of time. So there has to be a limit for the procedure. And from this point of view, it is irrelevant whether the legislation sets forth a specific period or a specific date as a time limit for the completion of the given administrative procedure. These references in itself may be a bit confusing, but there is a case law by the Curia on the administrative time limits. But at the end, the Curia adopted a decision and explained that imposing a sanction and adopting a decision are not necessarily functionally linked, which means administrative proceedings are not specifically aimed at the purpose of the sanctioning. And at the end, the administrative fine was not accepted by the Curia. In this, there is a very interesting legal argumentation in which the Curia also refers to the repressive nature of the competition law. And that's a very, very interesting outcome of the whole case, reflecting on the time frame of the original competition authority procedure. So from the Hungarian practice, this was the first case in which very, very interesting outcome came before the Curia.
Okay, Judith, thank you very much for sharing Hungarian experience. As I understand, Hungary had very early on introduced the settlement procedure for possibility for cartels, right?
It was in 2013, and this case took place, and the decision was imposed in 2016.
Thank you. Do we have anyone else with a question, maybe, or comment?
I think now finally everything works out. You can hear me, right? And see me. Okay.
Perfect.
I would like to first of all thank all the speakers. It was so interesting, all the presentations. It gave me so much food for thought. Starting with Portuguese experience, which is interesting because you don't apply settlements only in cartel cases. And what really made me think is the guidelines that you mentioned, which is something which I think was mentioned by other speakers as well, something which we should really think about preparing ourselves. Then Greek experience, which I noticed that you have only 15% fixed amount of reduction of fine in settlement cases. So we are here a bit more flexible. And your cases, also very interesting cases that you presented, like making it more concrete for us. And the French presentation, which gave me also a lot of food for thought, especially regarding the criteria. And finally, the practitioner's presentation, which was really excellent, Mr. Wijckmans. It was really good that you pointed out things which are good in our law, which I'm very happy about. We still haven't started applying it, but I can see that two things are probably very good already in the law, which will help us and practitioners in the future practice. But I also appreciate these points that you made about where might be a point of legal uncertainty for the parties. So this is just from me. I have a lot of questions, but we don't have much time, so I would rather leave it for others. But I just wanted to make this couple of comments, couple of things that caught my attention, and I really hope that we might probably be in touch further when we develop our own practice. So thank you very much.
Thank you very much, Mirta. If there's anyone else who wants to ask a question, now's the time. I just observed that the different countries have different scope in terms of using the settlement tool. So I think in Croatia, maybe it's only for cartel proceedings, but in all of the countries, as I gather, that we discussed today, you can use it for abuse of dominance as well, or other restrictive agreements. So what is your opinion? Is it better to have it very restricted to cartel settlements only, or should it be more flexible so it can be used in other cases as well? And then what is the interplay between settlement settlement tool and commitments if you go for the broader approach? If anyone of the speakers wants to comment on this.
Okay, I can address that issue. Of course, speaking from our experience, we find it more appropriate to have a broader tool. In our case, we've applied a settlement procedure also in relation to vertical restraints, gun jumping cases, not abusive dominance though. We have initiated settlement talks in cases, as I've said, that are pretty much clear-cut, in which we already have the evidence to find infringement. So the companies will only have to gain by settling, by reducing the exposure to reputational damages, because, as I've said before, their names is much more likely to be brought in the media under the standard procedure than in a fast-track procedure like settlements. So yes, I think that's that's the way to go, and only in relation to clear-cut infringements, because if the theory of harm, if we're trying to test a new theory of harm, that's a case that's more appropriate to follow through commitment decisions, or if we want to fix some problem that a new type of behavior is causing in the market, then through a standard procedure with penalty. That would be my approach.
Thank you very much, Maria. Anyone else, maybe?
Just a few words. I also agree with the fact that it's very interesting to have a broader scope for implementing a settlement procedure. In France, we also have a wide scope. We can also, for example, it's also due to the fact that we can prohibit some specific exclusivities. For example, with in islands like Guadeloupe or Martinique in the Antilles, there is specific prohibitions to avoid too high exclusionary practices from supplier side, and so in that we can prohibit that and so on. But it can be very well dealt with settlement procedure. So I think also, depending on the infringement, it can be very useful to have a wide scope. After, about the question about the commitment, as I said, I think our point of view in France is that it's more the exception than the rule, and especially that due to the fact that with settlements we don't have, I would say, a real market test or whatever. It would be because of the formal obligation we have with the procedure. It would be more discussed behavior, but it would be more these commitments would be linked to the negotiation of the transaction. And there is no all the capacity to discuss the commitments we can have through a market test or whatever. So I think also it's, and it's my personal opinion, I don't think that negotiation of commitment through settlement procedure can be very useful.
If I can add just another very practical element why it's useful to have settlement decisions beyond cartels, it's the fact that typically only one party will be involved, or two in the case of vertical restraints, or one in the case of use of dominance or gun jumpings. So the likelihood of success will be much higher of those settlement talks.
And in Greece, if I may add, the settlement procedure concerns only cartel cases, as I said during my presentation. However, as I said, we have one case of active cooperation regarding Coca-Cola company, in which the Hellenic Competition Commission actually followed the practice of DG.Com. But if you ask my personal opinion, I would prefer legal clarity. I would prefer these provisions in the Greek law, but it's a personal opinion.
Thank you very much. Mirta.
I don't know if Mr. Wijckmans wanted to comment something before I just give my comment. So
I'll keep it extremely quick then in that case. I must say, I'm coming from a jurisdiction, Belgium, like Greece, where we only have cartels that qualify for settlement. I see now the flurry of RPM cases that are being handled by the NCAs. For me, an RPM case, at least in my experience, would be an excellent candidate for settlement, exactly for the reason I think Ms. Melícias said. It's typically involving a limited number of parties. The facts in many RPM cases are pretty clear, difficult to deny, not very complex, and it would be a waste of your public resources to really go through all the hoops of getting an RPM case to a final decision and then maybe on appeal and what have you. Again, I would advocate in my jurisdiction indeed that they do, as apparently is the case in Portugal and France, and expand the possibilities also, for instance, to vertical hardcore infringements.
Right. Well, maybe in the next change of law, we can also consider this. This is a very good point. But what I wanted just to make a short comment about settlements and commitments, since Jasminka brought it up. In Croatian competition legal system, this won't be possible because we do not apply commitments in cartel cases. And for the moment, at least, we will apply settlements only for cartel cases. The second interesting point is that we also had Coca-Cola case, like colleagues in Greece, and we completed it with commitments. And very short while after us, the Slovenian colleagues, Slovenian Competition Authority had very similar case. It was also potential prohibited vertical agreements in distribution of non-alcoholic beverages. So it's very interesting that you mentioned this case and also that you used it in a form of a settlement, which I find very interesting in this case. So thank you.
Thank you so much, Mirta. Do we have any other questions, maybe, or any comments? We already exceeded our time, so I would like to thank you for your attention and to speakers for their really interesting presentations and comments. And Mirta, I give you the opportunity to close the webinar. Thank you, everyone, and I hope this settlement procedure tool will be used in Croatia. Maybe after we change something, but yeah, this is a start, at least.
Yes, exactly. This is the start, and I would just like to thank our speakers, all very interesting presentations. And I think now the Croatian expert public has a little bit more clear picture on how the member states apply it and how the practitioners apply settlements. We will just start applying it, so we'll see maybe in a year or two, maybe we can have another, hopefully live type of roundtable, not the webinar. And I would just like to finish by wishing you all the best in next year and for Christmas. And let's hope that from next year, we will all be able to meet again in person. So all the best. And thank you very much for joining the webinar today.